And greetings to everyone, and welcome to Summary Judgment, condensed from American jurisprudence. We're on to part 3. Before we begin, just remind everyone this is strictly for the entertainment and educational purposes of this YouTube broadcast, not to be used, misconstrued, or abused for anything legal, lawful, personal, private, business, tax, financial, or otherwise, so please don't do this at home. That said, let's get started. So we left off last time with section 22, and let's get over it here. Now, as I was doing this presentation here, we're going through a lot of the case holdings here from the 2008 supplement. Those were the most recent cases at the time I got this text here to adapt this presentation from. However, I'm using every case that was in that supplement, and there's quite a few. The reason being is because to look through and dissect cases that were used in summary judgment are brief. They don't include trials or evidence or juries or any of the other elements that would be found in most other trial cases. Therefore, it's an efficient way for us to get the practice of going through very many cases in a short amount of time, but still applying the same principles we'd use for even a very complex case. That said, let's get started. So section 22 starts with generally the motions, affidavits, and etc. A party moving for summary judgment need only explain...
Y'all have a ride 6 says, but please be smart enough to at least try this shit at home.
Okay, well, that's on the advice of people that are in the chat is fine. But for my intents and purposes, I want to try and just stick with our gracious and generous corporate overlords here to make sure that they're happy with the presentation. Let's continue. A party moving for summary judgment need only explain the basis for its motion and identify supporting materials, not necessarily provide affidavits that specifically negate the opponent's claim. So, interesting here, typically the affidavits don't necessarily negate, they're usually in the affirmative. However, of course, it's not necessarily provide this. It seems a reason why. So let's read along. The moving party need only explain the basis and identify supporting materials. There's no need to support with affidavits that specifically negate an opponent's claim. Then the moving party shows absence of evidence rather than disproving non-moving party's claim. So it's not a rebuttal to the non-moving party's counterclaims and such. It's a moving party showing the absence of evidence. And here we have the Federal Rule of Procedure 7B1 applies to summary judgment motions. But we have a caution here. Affidavits that track the language of a statute are of conclusory character and amount to mere assertions of ultimate facts, and are ordinarily insufficient to support summary judgment. So an affidavit that just tracks language of a statute, those are of conclusory character. So they're just making conclusions. And as we learned before that the conclusions don't belong in the affidavits. They're firsthand knowledge. All right, let's proceed. So let's go over some of these cases. Here's one for no express affidavit requirement. There was no express or implied requirement in Rule 56, that's Rule of Federal Procedure 56, which relates to summary judgment, as we went over in detail, I believe, in Part 2, that the party moving for summary judgment support its motion with affidavits. So there's no express or implied requirement in the federal rules that the party moving for summary judgment support its motion with affidavits. Now, as we learned before, the affidavits are kind of the bedrock of a lot of what's being presented as far as evidence for the summary judgment. But this is from Bickle versus Cyberling, and that's Third Circuit District 2004. Now we get to the certification requirements for affidavits. This is a tricky one here, and good to pay attention to this. Letter from party's lawyer recounting a witness's unsworn statement on which the witness responded to the request. He confirmed by signing below that these statements convey an accurate representation of some of the things that you advised us. Oh my gosh, that's the letter from the party's lawyers. He said, the lawyer says this, confirmed by signing below that these statements convey an accurate representation of some of the things that you advised us. By affixing his notarized signatures under the words, I confirm, It failed to satisfy the statutory requirement that witnesses certify truth of unsworn statement by stating that it is under penalty of perjury or using other language substantially similar in form, such as an affirmation if you're not going to swear, or under penalty of law, something of that nature. And thus, it was not admissible on motion for summary judgment, because confirmation is not affirmation under penalty of law or penalty of perjury. There's none of that language in there. They just simply said, I confirm. So, yeah, that didn't hold water as far as being admissible for the motion for summary judgment. So, pretty weak there, letter from the party's lawyer. All right, let's move along. All right, come on. There we go. Here's one for insufficient affidavit for medical malpractice claim. This is a good one here. The affidavit of a board-certified orthopedic surgeon who reviewed medical records of a prisoner who broke his hip.
Override 6 says affidavit of change of status motion of default requiring the district attorney in court to show probable cause in the failure to show the default is upheld and file notice of default. Override 6 says then the judge writes the summary judgment.
Yeah, there's sua sponte. We'll get into some of that too in here. But right now, this one here is an insufficient affidavit for a medical malpractice claim. Now, think about this. This is a medical malpractice claim that actually, I believe this is for Fitzgerald versus Corrections Corp of America, 10th Circuit, 2005. This is a prisoner who was alleging malpractice from, I guess, the prison medical team there. However, this Corrections Corp of America, they got an affidavit of a board-certified orthopedic surgeon, I assume this is an expert witness, who reviewed medical records of prisoner who broke his hip. Oh, he just broke his hip. Did not have any probative value in support of summary judgment motion against the prisoner's claim, which alleged that the treating physician violated his Eighth Amendment civil rights. Since the affidavit did not provide any supporting facts for his conclusory allegation that the care rendered by the treating physician was appropriate or met or exceeded accepted standard of care. So he just made a conclusory allegation that, it was acceptable, care by reviewing medical records. And that didn't, it seems like that was not held. It did not have any probative value. All right. We might hear some more from Mr. Fitzgerald later. Let's continue on to the motion for summary judgment without identifying facts. This is a particular kind here. Motion for summary judgment on claim that retailers violated the Clean Air Act. So it's about a motion for summary judgment on claim that retailers violated the Clean Air Act by selling pesticide for reptile ectoparasites containing a Class II substance. It did not need to identify facts that would support finding that the retailer sold pesticide, where retailers admitted they sold pesticide in their response. There's an interesting one here. So without identifying facts. So I guess the facts that they were selling is the retailers admitted that they sold pesticide. Whether they knew they were selling Class II substances, I guess, was part of that case there. But the summary judgment seems like it didn't. They did not need any way of having to identify those facts, because of the admission by the retailer saying, "Yeah, we sell pesticide." Let's move along. Here's the untimely reply brief and summary judgment motion. Employer. Now we'll see some interesting ones here when the timing comes. The employer university's reply brief, which was submitted in support of its motion for summary judgment in employment discrimination action after the deadline passed, would not be considered, absent showing that the delay was the result of employer's excusable neglect. Court would not sua sponte find excusable neglect by employer. So in this case here with Judgement versus Pittsburgh State University, Strangely enough, District Court, Kansas, 2003. But nevertheless, this one here, where the brief, the employer's university reply brief in support of the summary motion judgment past the deadline would not be considered. There is no excusable neglect, and the court wouldn't find that excusable neglect if they're not going to declare it, I guess. All right, let's move on to the contract as part of pleadings in summary judgment. Oh, this is so bad. The contract between the subscriber and internet service provider, ISP, the contract between them, so this is your customer and your ISP, was integral to the subscriber's claim arising from ISP's alleged release of his name, age, and address to police officer. And thus the entire contract could be considered as part of the pleadings on the ISP motion for summary judgment based on the contract's forum selection clause. Oh, Lord. That's Hughes versus McMahon, whatever, Massachusetts, 2002. All right. Now we're on to the identification of inadmissible statements. The defendant challenging admissibility of statements in expert summary judgment affidavit on the ground that some statements in the affidavit had not previously been properly disclosed was required to identify the statements at issue. So you can't just say some of those statements weren't, what does it say here? That some statements, you have to be identify the specific statements at issue. Otherwise, then it's not substantial. All right, corporate affidavit in employment discrimination action. Oh boy. Summary judge. Now this is really interesting here when you look at in this way here. The summary judgment affidavit. This is an affidavit for summary that's going to be attached with the summary judgment motion here of employer's chief operating officer. So as the COO of the company would not be stricken. So it's going to stay in employment discrimination action, even though the COO did not have personal knowledge of the facts of the case. And the affidavit contains statements reflecting the employer's legal positions. The affidavit was permissible means by which employer, a corporation, could state its position and incorporate documents. And employer, a corporation, did not rely on any of the factual statements in affidavit to support its motion for summary judgment. So that's an interesting one there too, that they, I guess the COO could sign the affidavit because a corporation can't sign the affidavit, but because it's the will of the corporation, he can be guided to do that and act in that capacity, it seems, as a corporation. And I guess as a corporation, how can it have personal knowledge of anything anyways? So this is kind of a real shaky area there with affidavits and corporations. But again, this is where the nexus with contracts runs into this with summary judgment. Remember the contracts. All right, let's continue here. Let's look at the summary judgment standard as it's applied. A summary judgment, here's key, taking us back to part one. Summary judgment is appropriate if the pleadings, depositions, answers to interrogatories, and admissions on file, together with the affidavits, if any, show that there is no genuine issue of material fact, and the moving party is entitled to a judgment as a matter of law. And that's recent 2007 from Waliluku Agribusiness. All right, versus Assam. All right, now let's look at the more grim here, the testamentary capacity in probate proceeding. In opposition, which we'll be getting into in the next part, so make sure you're subscribed, so be ready for that next live stream. In opposition to petitioner's prima facie showing that the descendant was alert and of sound mind at the time of execution, and that he knew the nature of the act he was performing, the extent of his property, and the natural objects of his bounty, objectant failed to raise a triable issue of fact as to the descendant's alleged lack of testamentary capacity on summary judgment motion in contested probate proceeding. So they came up saying, oh, he wasn't thinking right with zero substantial facts to back it up. No triable issues. So that's in Ray Tuccio. Leave to appeal denied. There we go. Let's move along. And medical malpractice limitations period tolling. This is interesting here that the summary judgment affidavits submitted by registered nurse and certified rehabilitation registered nurse, along with the patient's medical records, were sufficient to raise a genuine issue of material fact as to whether the patient had been continuously mentally incapacitated since her surgery for the purpose of determining whether the 2 years limitations period for medical malpractice lawsuit filed by the patient's mother was tolled due to the patient being in a continuous vegetative state. So there you go. Having some of that good expert witness was able to prevent that period of tolling. There we go. That's Yancey versus United Surgical Partners, something in Texas 2007. Now we have the no evidence summary judgment claims. So a no evidence summary judgment. In a motion for a summary judgment containing only no evidence summary judgment claim attaches evidence. So it's a no evidence summary judgment claim, but they attach evidence anyways. That evidence should not be considered unless it creates a fact question, but such a motion should not be disregarded or treated as a motion under traditional summary judgment claims. So if it creates a fact question, then I guess it should not be disregarded or treated as a motion under traditional. So then it would be treated it still has to be treated as a no evidence summary judgment claim. That sounds complicated. Texas 2004. Let's move along. How about burden of proof? We went over the burden of proof in the last live stream, but it was good. But how about burden of proof for limitations defense? A defendant moving for summary judgment on the affirmative defense of limitations has the burden to conclusively establish that defense. So a defendant moving for the summary judgment on the affirmative defense of limitations has the burden to conclusively establish that defense. So there we go. G Property Management versus Multivest Financial Services of Texas. And that was 2006. Let's move along. How about inadmissibility of unauthenticated letter? Oh boy, another letter. Here we get a letter from Senior Assistant Attorney General in another case regarding the tax-exempt status of parking garage. Was not admissible in summary judgment hearing on city's cross-claim seeking a judicial determination regarding the garage tax-exempt status, where the city attached the letter to a memorandum it filed with the Superior Court and made no attempt to provide a supporting affidavit on which to base the admission of the letter. So they try to sneak that in, without an affidavit stating what basis for the admission of that letter about the tax-exempt status. Sounds pretty corrupt to me to see. Spokane, Washington, 2007. But I digress. All right, here we go. Finally, on to Section 23. So that was quite a few cases we covered there for Section 22, generally. Now we're on to the plaintiff, by the plaintiff or plaintiff, the summary judgment. Under Federal Rule 56 and similar state rules, we saw most state rules are almost identical to that Federal Rule 56. A plaintiff seeking to recover upon a claim may move for summary judgment after the specific time periods, with particular requirements for supporting evidence. So, from Federal Rule 56, Civil Procedure, a plaintiff may move for summary judgment after 20 days from commencement or after adverse parties' motions. Plaintiff required to submit affidavits establishing the cause of action. Reliance on materials other than affidavits, however, is permissible. The plaintiff must disprove or establish legal insufficiency of affirmative defense, and summary judgment granted if no genuine issue of material fact exists. So let's get some cases to get this more clear. So we have failure to respond to statements of fact. Acceptance for summary judgment purposes of defendants' entire statements of fact in support of their motion for summary judgment was warranted, where plaintiff failed to submit document responding particularly to each numbered paragraph in the defendant's statement, and providing citations to supporting evidentiary materials as required by local procedural rule governing summary judgment proceedings. So this is a pretty interesting one from Smith versus Lambs, 7th Circuit, 2003. See, acceptance for the summary judgment purposes of defendants' entire statements of fact in support of their motion for summary judgment was warranted. Okay, so even though some of those statements perhaps might not have been warranted to be admitted, the plaintiff failed to submit a document that responded particularly to each numbered paragraph. So, word to the wise there. Then we get to the insufficient affidavits in defamation action. Oh, so with defamation, summary judgment affidavits submitted by plaintiff in defamation action were properly stricken in defendant's summary judgment motion based upon conditional privilege, where affidavits did not support claim that alleged defamatory statements were published to others. So this is between, okay, so it's not defamation if it's privileged communications, in which case it wasn't published to others. Therefore, I guess the affidavits stating that was something was properly stricken. It was improper for the case. That's Thomas versus Pacific Corp. 10th Circuit, 2003. All right, and I hope everyone's paying close attention because at the end of this presentation, we're going to have a special surprise. So stay tuned here, and let's see, how's this thing? Go on to the next slide. Let's try this again. There we go. How about first-time allegations in summary judgment opposition? Look at this one. A pro se plaintiff, an attorney, who he could not raise allegations of misrepresentation for the first time in his opposition to a defense motion for summary judgment. Of course not. What, misrepresentation of himself? The plaintiff failed to plead the claims or otherwise give defendant fair notice that he was relying on them. Wow. Kroger versus LegalBill.com. That's going to be an interesting one. So, 2006. All right, then we have the insufficient expert affidavit for product defect claim. The summary judgment affidavit of motorist expert. A motorist's expert. That sounds like a fun job. Failed to identify a defect in motorist's pickup truck at the time it
Bill
left.
Limit 4426 says he could claim ineffective counsel, perhaps, sir.
Yeah, that's what I was thinking here. Ineffective representation of counsel, but, you know, I mean, that's kind of calling yourself out. All right, I digress. So let's see here. We are on to the fun one here, the motorist expert. This is going to be a great occupation here. He failed to identify a defect in the motorist pickup truck at the time it left the manufacturer. Oh boy, so he goes there to check it out too. Nice. And thus, his affidavit was insufficient to show the manufacturer was liable for a product defect for fire that the expert suspected was caused by the truck's electrical system. Well, he should have been there at the time it left the manufacturer, I guess. But either way, his suspicion might be okay, but an affidavit to show it was liable for the defect for the fire that he suspected was not. That was insufficient. So there's probably a different way, maybe expert testimony or something to that effect, but that affidavit was not sufficient. So let's continue. All right, now we get to the timeliness of objections to evidence. Oh boy. A movement's objections to the competency of a non-movement's evidence that are filed the day of the hearing on a motion for summary judgment are not untimely. Oh, good. And may be considered and ruled upon by the trial court. So a movement's objections to the competency of a non-movement's evidence that are filed the day of the hearing. So that's Bradford Partners versus Fanning in Dallas, 2007. And how about failure to respond to no evidence summary judgment? So how about the no evidence summary judgment earlier? Here, the plaintiff mother. See, plaintiff's mother, by failing to respond to no evidence summary judgment filed by defendant attorney who had been appointed as attorney ad litem to represent her in child protection proceeding, to represent her in a child protection proceeding. Plaintiff mother, okay, failed to meet her burden of specifically pointing out evidence raising a genuine issue of material fact, and thus the trial court was required to grant no evidence summary judgment to attorney. Wow, I don't know about that one. That's Martinez versus Leeds, again, Texas, 2007. That one sounds pretty confusing to me. All right, let's continue here. Finally, on to section 24. How about summary judgment motions by defendant? Under Federal Rule of Civil Procedure 56 and similar state rules, a defendant against whom a claim is asserted may move for summary judgment, but must meet specific burdens to prevail. So let's look at these specific burdens. The defendant may move for summary judgment when? At any time. A defendant must establish prima facie case that defeats the plaintiff's claim. The defendant must prove essential element of plaintiff's claim does not exist, which is difficult to prove something doesn't exist. Defendant must assert elements of cause of action for which no genuine issue exists. And the defendant's motion challenges sufficiency of complaint. So we saw about sufficiency, like the affidavits and such. Material facts, of which no genuine issue exists. Lots of things in here. Burdens by defendant moving for summary judgment. So let's see how this, where the rubber meets the road. Insufficient affidavit, not requiring contrary evidence, though. Here's where affidavit of orthopedic surgeon. Oh, this is again here, Mr. Fitzgerald versus Corrections Corp of America from 10th Circuit 2005 that we read earlier. Here's where the affidavit of the orthopedic surgeon was conclusory and insufficient to support a motion for summary judgment on state prisoner's medical malpractice claim against treating physician under Oklahoma law. The prisoner was not required to produce a contrary affidavit. Good for him. All right, then we have continuance without supporting evidence. A continuance of consideration of motion for summary judgment was not warranted, where defendant failed to submit affidavit. And there was no specific identification of relevant evidence which, when available, would foreclose summary judgment. Wow, so the continuance was not warranted where the defendant failed to submit an affidavit. And there was no specific identification of relevant evidence, which, when available, would foreclose the summary judgment. So there it is. That's CNA Insurance Company versus Little in Alaska, 2005. Now we're on to the insufficient evidence for prescriptive easement. So if you have rights, cops have duty is still here. I know he's familiar with this one here. Summary judgment evidence was insufficient to establish that neighbor's predecessor or its agents used a road over landowner's property continuously for at least 20 years as required for neighbor to obtain prescriptive easement to use the road. There was no evidence of any use by predecessor before or after aerial photograph, which showed road running to predecessor's property. Photographs which showed gap in wooded property did not show that predecessors continued to use road, but only that the road existed and it was used by someone. And neighbor's own affidavit in which he testified that he lived in the area and personally knew of continuous use by predecessor and its representatives for all of his life was conclusory. Wow, look at that. So there it is. That's insufficient for prescriptive easement because that was found to be conclusory, which I guess he personally knew of continuous use by the predecessor and its representatives for all of his life. Yeah, that sounds a little conclusory, I guess. Let's move along. Okay, we're on to section 25, the requirements as to affidavits. Personal knowledge of affiant. Federal Rule Civil Procedure 56 and similar state rules provide specific requirements for supporting and opposing affidavits and summary judgment proceedings, emphasizing personal knowledge and admissible facts. Affidavits must be made on personal knowledge. Affidavits
Shaggy
must
Hippie 1776 has donated $5.
Salute to you, Shaggy Hippie 1776, and thank you very much. Very gracious of you. So thank you. As that said, we're going to continue on here and learn some more about these summary judgments. The affidavits, being one of the key elements in here, must be made on personal knowledge, must set forth admissible facts. Admissible facts. The affiant must be competent to testify to matters stated. And the affidavits containing hearsay or conclusions are insufficient, as we saw, those conclusory allegations and such. Bad faith affidavits may result in sanctions. So look at that. Bad faith affidavits may result in sanctions. Here's our caution. Federal Rule of Civil Procedure 56 and similar state rules do not require that the moving party support its motion with affidavits. If the non-moving party bears the burden of proof on a dispositive issue, the summary judgment motion may rely solely on pleadings as to that issue. So it's not necessary to have the affidavits and these other burden of proof when depending on the situation. So similar state rules do not require that the moving party support its motion with affidavits. Not a requirement if the non-moving party bears the burden and the summary judgment can rely on the pleadings. So let's look at some of these requirements to the affidavits. Authentication of documents in summary judgment. In a summary judgment motion, documents authenticated through personal knowledge must be attached to an affidavit. And the affiant must be a person through whom the exhibits could be admitted into evidence. Person through whom. This is where you get that subpoena deuces take 'em here. However, a proper foundation need not be established through personal knowledge, but can rest on any manner permitted by rule of evidence, providing approaches to authentication, or rule providing that self-authenticating documents need no extrinsic foundation. Self-authenticating, like if you got a certified record from the clerk or some matter like that where it can come with some type of authentication in that form of certification, those can be judicially noticed as self-authenticating and then referred to in the motions. That's Orr versus Bank of America. Oh boy, 2002, California. So very important in those kinds of things with the affidavits through personal knowledge, and it must authenticated through personal knowledge must be attached to an affidavit. Old affidavits without current competency requirement. A district court could consider a 14-year-old summary judgment affidavits offered
Yellow
by
Override 6
arrestees.
says, I would rather an affidavit that accompanies the show of evidence supporting the affidavit, and the affidavit should claim to take your status away from the status they are accusing.
Yeah, indeed. If the affidavit, if their claims aren't rebutted by an affidavit, and again, particularly, that's the best way to do it because again, they become presumptions. They're standing presumptions unless rebutted, and the best way to rebut would be through the affidavit because that would be admissible as evidence if it's particular and direct and relevant. That said, let's go on to the old affidavits without the current competency requirement. This is great. The district court could consider a 14-year-old summary judgment affidavit offered by arrestees in excessive force action against the town without requiring arrestees to show that affiants were currently competent and available to testify, of course, 14 years ago, where the affidavits facially satisfy the requirements of summary judgment rule. And the town presented no evidence that the affiants were no longer available. So there's your thing. If you're not countering it or rebutting it, the court doesn't necessarily have to bring it up themselves. That's Amnesty America versus the town of West Hartford. And that's second district, 2004. Let's look at the authentication requirements for documents. In a summary judgment motion, documents authenticated through personal knowledge must be attached to an affidavit, and the affiant must be a person. We read this one, didn't we? I guess I got in here twice by accident. All right, so we have expert testimony and summary judgment affidavits. A summary judgment affidavit may not contain expert testimony unless the affiant has first been designated an expert witness. So only the expert witnesses can give expert testimony to an affidavit. That's Bryant versus Farmers Insurance Exchange, 10th Circuit, 2005. Rolling along here, we're on to the unsigned and unauthorized affidavit inadmissibility. Affidavit which was unsigned and not notarized was not admissible in support of summary judgment motion. Great one here. That's Howard Ahmad versus Chicago School Reform Board of Trustees, Northern District of Illinois, 2001. And now we're on to the affidavit based on information and belief. Because affidavits proffered in support of a motion for summary judgment must be based on personal knowledge. Affidavit based upon information and belief is insufficient as a matter of law. And that's Wells Dairy versus Travelers Indemnity of Illinois. That was the Northern District of Iowa, 2003. Moving right along, personal knowledge requirement for the affidavits. Fact that testimony contained in summary judgment affidavit filed by Indian Band's Motor Vehicle.
Yellow Override 6 says, kinda like you, an unsung hero with this work you do.
Nice, thanks. I appreciate it. Now, on this one here, I'm trying to figure out an Indian band. This is like here in Florida we have the Seminoles, and there's Billy Tiger. I know had a band, and they did some pretty good music. If that's the kind of band we're talking about here, but let's see here. It seems like the bandwagon, literally. Fact that testimony contained in summary judgment affidavit filed by Indian Band's motor vehicle registrar was identical to some information contained in another band official's affidavit did not compel finding that registrar was not competent to testify to facts contained in her affidavit in band's action seeking recognition of its motor vehicle registrations from state. Wow, that's the Indian Band of Potawatomi Indians versus Wagon, 2003, Kansas. That's an interesting one there, too. And then we have the tribal official's personal knowledge. Luckily, this is the same case. Indian Band's motor vehicle registrar had personal knowledge of and was competent to testify in summary judgment affidavit as to matters pertaining to facilities located on reservation, tribal motor vehicle registration, and use of government vehicles, and bans action seeking recognition of its motor vehicle registrations from state, where supplemental affidavits stated that all statements in supplemental and prior affidavit were made upon personal knowledge. Wow, that sounds pretty complicated there, but it looks like a vehicle registration thing between the Indians and the state government here. That'd be an interesting one to check out, and that was in 2003. Now we're on to the executive director's personal knowledge. And still, same case. Great. The executive director of the Indian band's tribal government was competent to testify in summary judgment affidavit to matters involving band's governmental functions, activity of its members, and facilities available to members on the reservation, and band's action seeking recognition of its motor vehicle registrations from state, where affidavit averred that he was familiar with the band's governmental function and that all directors of various tribal government departments reported to him. So he's making an averment here, stating facts. He averred he was familiar with the band's governmental functions. So, geez, governmental band? Trying to figure out what this band is doing. Patriotic songs or something? All right. We're moving along here. This is the Prairie Band of Potawatomi Indians. That sounds like the search term to find out about this band. Maybe they have some good music. We'll find out. Affidavit lacking personal knowledge explanation. The affidavit of supervisor for employer was disregarded to the extent that it did not explain how or why supervisor had personal knowledge about particular subjects in motion for summary judgment. So the supervisor for the employee was disregarded. He could not explain how or why he had personal knowledge. That's Kephart versus Data Systems International, probably incorporated as Kansas 2003. Let's move along. This can almost be humorous to some extent. All right, let's look at personal knowledge requirement for Medicaid benefits. Jeez. Portion of parents' summary judgment affidavit stating that the school district received Medicaid benefits for RL was not admissible because it was not based upon personal knowledge, since only school district officials would have had direct personal knowledge where a school district received Medicaid benefits, and that any knowledge plaintiff parent would have received related to school district's medical benefit would have come from district employees. Nah, so sweet. That's DL versus Unified School Districts. That's Kansas 2002. All right, then we have personal knowledge for SEC financial requirements. Lack of personal knowledge required striking of summary judgment affidavit statement by marketing representatives of security seller. Oh boy, that several prospective buyers in proposed private placement did not satisfy the Securities and Exchange Commission financial status requirements for participation, offered in suit alleging breach of subscription and shareholder agreements. Lack of personal knowledge by the marketing representative. Okay, so Pinnacle Communications International versus American Family Mortgage. Wow, 2006, Minnesota. Now we're on to the personal knowledge limitations in affidavits. Oh, here's a club owner's summary judgment affidavit in an action challenging constitutionality of city ordinance prohibiting sexual contact. Sounds like a fun club, huh?
Yalamba Ride 6 says or Potawatomi.
Potawatomi? Okay. So there it is. That's the band we need to look up. I guess we could put it in the chat, but I digress here. All right, so the personal knowledge here, the club owner's summary judgment affidavit in an action challenging the constitutionality of a city ordinance prohibiting sexual contact could not include statements about aspects of police raid of his establishment that he did not personally observe. He wasn't there for the raid. Well, geez, I guess that's why he's still standing, huh? That's Ways versus City of Lincoln in Nebraska, 2002. Speculation's not permitted in affidavits. That club owner's speculations, same case, as to meaning of the city council member's silence when asked whether city ordinance prohibiting sexual contact was intended to put his club out of business, did not constitute facts within the owner's personal knowledge, and thus could not be included in the owner's affidavit in opposition to city's motion for summary judgment in action challenging the constitutionality of the ordinance. Wow, that sounds like not a fun city. Let's move along. Now we get the Medicaid waiver services facts in affidavit. Facts in summary judgment affidavit that more home and community-based services were required because New Mexico closed its public institutions, that it took 40 months instead of 60 months for individual in New Mexico to receive waiver services in prior year, and that the state's multiple non-waiver services provided needed services to individuals on central registry prior to allocation into waiver services, were relevant to lawsuit over funding and support of waiver programs under which participants would receive Medicaid benefits in home or community-based setting. So the facts of summary judgment, all these facts here were relevant. All right, let's move along. Compliance with local rule requirements. African American employees' statement in opposition to the employer's motion for summary judgment on race discrimination claims would not be dismissed for failure to comply with local rule requiring non-moving party to submit a paragraph-by-paragraph response to movement statements of material facts, where the employee's 56-page statement compiled with the spirit of the rule by citing to the record and made it clear that there were disputed issues of material fact. Oh boy. Employers, wait a second here. See, okay, all right. So the employee's statement in opposition to the motion for summary judgment would not be dismissed. So that would be granted, I guess, for failure complete. Okay, because of the paragraph by paragraph. But he gave a 56-page statement that complied with the spirit of the rule by citing to the record. So he's citing to the record. Remember, the citations are required, and made it clear that there were disputed issues of material fact. Good ruling there. Kennedy versus J.P. Morgan Chase. Wow, and that's Southern District of New York, 2004. Let's move along. Hope you all are going to be sticking here to the end because it's going to be a really good. There we go. All right. Experts' personal knowledge versus secondhand information. Expert summary judgment affidavit submitted in connection with building owner's claim that damage to the building's facade was the result of water infiltration. It was not excludable on the ground that it was not based on his personal first-hand knowledge, even though the expert stated that he had discussed the matter with other unidentified engineers, where experts' conclusions did not appear to be based solely on his discussions but relied on his personal first-hand knowledge and other reviewed sources of information. Wow. So the expert summary judgment affidavit was not excludable, so it was able to be included. So I guess it did rely on his first-hand knowledge and other reviewed sources. So he was able to let his affidavit was permitted. Okay, and we have state of mind hearsay exception. This is an important hearsay exception. Statements in employee's affidavit that his doctor told him he would have to perform sedentary job work and could no longer perform strenuous work were admissible at summary judgment stage of an ADA action under state of mind hearsay exception to show his then existing state of mind and his reasons for requesting transfer and sitting down. So, state of mind hearsay exception. His doctor told him he'd have to do this because it's under state of mind hearsay exception that his then existing state of mind. and his reasons for requesting the transfer and sitting down. Interesting. That's Gallimore versus Newman Machine Company in North Carolina, 2004. All right. Well, he got his sit down job, it looks like. Here's a lay opinion testimony in the ADA action. Same case. Statements in affidavit of employee's wife regarding employee's physical limitations resulting from his hip replacements did not require the wife to possess scientific, technical, or other specialized knowledge so as to render statements inadmissible lay opinion at summary judgment stage of ADA action. So statements did not require. So I guess they accepted her statements. That okay. Never mind. So not require wife to possess this. So as to render statements inadmissible. Okay. Lay opinion at summary judgment. Inadmissible. Sorry, wife. All right. Inadmissible hearsay and affidavit. Portions of affidavit submitted by a postal worker in opposition to summary judgment motion in employment discrimination action would be stricken, as they contained irrelevant statements to workers' claim. They were not based on the client's personal knowledge, and they contained inadmissible hearsay. So the postal worker is pushing it there, and that's also 2003 Middle District of North Carolina. All right. Now we're on a corporate officer's testimony in Title VII action, a summary judgment affidavit of employer's vice president would not be stricken in the Title VII action, even if vice president had no management responsibilities where he testified from personal knowledge as lay witness with respect to hiring, comparative qualifications, and unequal compensation between male and female employees. And there were no inconsistencies in Vice President's declaration testimony regarding decision to hire male employee and his deposition testimony. All right, won't dive too deep in that. Then we have argumentative affidavit admissibility. This is interesting here. Employee's affidavit would not be stricken in the Title VII action. This is the same Klaus versus Rogel and Hamilton Company of Ohio, 2006. This employee's affidavit would not be stricken in the Title VII action, even though it was argumentative in tone, where it was based on what employee personally saw, heard, or did during her employment, and there was no material deviation between her statements in affidavit and her previous deposition testimony. All right. So even though it's a little argumentative, it was factual, and it was based on personal knowledge. All right, we're on to the unsworn declarations in summary judgment. Unsworn declarations of plaintiff and two of her co-workers, which were signed under penalty of perjury and dated, had the same force and effect as an affidavit. So unsworn declarations of plaintiff and her co-workers, which were signed, but they were signed under penalty of perjury. Even though they were unsworn, they were signed under penalty of perjury and dated, had the same force and effect as an affidavit, and could be considered on summary judgment to the extent that they contained otherwise admissible evidence. That's Hess versus Multnomah County, and that's Oregon, 2001. Then we have the inadmissibility of employee interview summaries. Oh boy, interview summaries. Portions of employee interview summaries by county's affirmative action office were not admissible as part of plaintiff's response to summary judgment motion, where plaintiff did not submit a declaration from employee to substantiate what she told someone else or to prove that certain events happened and how she felt. Exhibits were not self-authenticating under evidence rule and are hearsay since they are clearly not based on the investigator's personal knowledge. So, there we go. The employees' interview summaries are inadmissible as far as being portions and incorporated here, it seems, into exhibits and not self-authenticating unless they're attached to an affidavit. I see. Okay, good. Let's move along. Now we're on to authentication of certificate of occupancy. Exhibit which purported to be certificate of occupancy for restaurant and which appeared to be signed by business official for municipality, submitted as proof on summary judgment that the building's maximum capacity was 360, was not properly authenticated by affidavit of attorney which stated that the exhibit was true and correct copy. Since attorney did not have personal knowledge of the certificate, and that attorney did not witness signing of certificate by official, and he was not familiar with the signature of the official, and the affidavit from the official had not been submitted to the state that official signed the certificate, and that he was authorized to sign as an official for the municipality. Yikes. That's Logan versus City of Pullman, Washington, 2005. All right, now we're on to an attorney's declaration for document authentication. An attorney's summary judgment declaration stating that exhibit that purported to be oleoresin capsinum spray, OC spray, instructor materials was true and correct copy. Stating that the exhibit that purported to be OC spray instructor materials. Okay, so it's not the actual OC spray, it's the OC spray instructor materials, was true and correct copy of documents received through public disclosure requests to municipality, did not authenticate the exhibit since the exhibit had been submitted as attachment to attorney's declaration who did not have personal knowledge of the documents rather than an exhibit list. So they should have got those authenticated. Same one, Logan versus City of Pullman. What are they doing with all that OC spray? All right. Now we're on to the state of mind exception in financial advisor's affidavit. Oh, Lord. Summary judgment affidavit by financial advisor for financial services company, in which advisor stated that he asked descendant about beneficiary change on descendant's individual retirement account, the IRA, and that he confirmed he wanted his sons to be beneficiaries. It was not offered to prove what descendant remembered, but rather was a statement of his then existing intent for his sons to be beneficiaries of his IRA, and thus came within hearsay exception for a declarant's then existing state of mind and was admissible in widow's action against financial services company regarding distribution of IRA proceeds. Let's see, affidavit by the financial advisor. Wow. That's Davis versus Stern, Aggie, and Leach. I don't know if I'd want a financial advisor named Leach, but I digress. That's Alaska, 2007. Next, we have personal knowledge requirement for jurisdiction. Insurance Department employees summary judgment affidavit stating that Connecticut Appraisal Company provided a list of appraisals performed for non-admitted automobile liability insurer, failed to satisfy the personal knowledge requirement, and could not establish a constitutional basis for exercising general personal jurisdiction over insurer in commissioner's action to enforce subpoena. Oh boy. That's Cogswell versus American Transit Company, 2007. And we're on to the inadmissibility of non-compliant affidavits. An affidavit which fails to meet the criteria of the summary judgment rule is not to be considered by the court in ruling on a motion for summary judgment. State Nixon versus McIntyre, 2007. In transfer denied. Is that Missouri? All right, then we have late witness sufficient for causation issue. Contractor who sued homeowners for negligence arising from an incident in which he suffered a heart attack shortly after allegedly suffering an electric shock from loose wires in the homeowner's residence, was not required to produce expert testimony that electric shock caused his damages within a reasonable medical probability. in order to create a fact issue precluding summary judgment on the issue of cause in fact. Lay testimony providing direct evidence of the prompt onset of symptoms following the electric shock, combined with expert medical testimony that electric shock could have caused the heart attack, was sufficient to raise an issue of fact as to causation. I would agree. Texas, 2007. Great. All right, now let's look at what we just went over here. A summary of our summary judgment, motions, affidavits, and others, etc. So summary judgment standards. The moving party must show absence of genuine issue of material facts, so no dispute on the facts. There's no requirement to disprove opponent's claim with evidence. The defendant must establish a prima facie case defeating a plaintiff's claim. Then we have the affidavit requirements. It must be based on personal knowledge. It must set forth admissible facts. The affiant must be competent to testify, and the conclusory affidavits are insufficient. Our key cautions we learned here are affidavits tracking statutory language are insufficient and conclusory. Bad faith affidavits may result in sanctions, and failure to meet affidavit requirements leads to inadmissibility. So the party responsibilities. The plaintiff must establish cause of action and disprove affirmative defenses. The defendant must prove essential element of plaintiff's claim does not exist. And timely objections to evidence are crucial. All right, now that takes us to the best part. For those of you that stuck around, we're going to have our fun quiz here on summary judgment. So the way we do this, we'll read out the question, and you can pipe up in the chat with the number and a letter of your answer. So starting with question 1, is it true that you always need sworn affidavits to support a motion for summary judgment? Answer A would be yes, that's the golden rule of summary judgment. Answer B, no, you can rely on other evidence, like depositions. C, only if you're the plaintiff. Defendants always need sworn affidavits. Or D, it depends on the judge's mood that day. So if you were going to pick D, you would put in the chat 1D, but I wouldn't be picking D. All right, that's the case. Let's move to the next question. Waiting for anyone that wants to pipe up in
Bill
chat.
Limit 4426 says 1B.
All right, so we get an answer for B for question 1. All right, noted. On to the question 2. An affidavit describes a person's visible physical limitations, but the author isn't a doctor. Is this evidence admissible? All right, we went over this. It was kind of tricky. A, no. Medical conclusions.
Facetious use expert 587 says 1B.
All right, so we got 2 votes on B for number 1. All right, noted. So we have, for question 2, an affidavit describes a person's visible physical limitations, but the author isn't a doctor. So visible physical limitations.
Facetious use expert 587 says 2B.
2B or not 2B? All right. So B is yes, as long as it's based on personal observation and not a technical analysis. A is no, medical conclusions require a medical expert. C is no, all affidavits about medical issues must be from experts. Or D, yes, anyone can describe what they see about another person. So we have 2 answers for no, 2 answers for yes, but only one of all 4 is correct. So we had vote for 2B. And let's proceed to the next set of questions as you guys get ready for...
Bill Limit 4426 says, I agree, 2B.
All right, so it's 2B or not 2B is the question here. But question 3 is, a party submits an affidavit.
Facetious use expert 587 says 2D. I should read all the answers first.
Let's see here. Well, we'll see. You get your answer down there. Let's move along here. You said D. All right, let's move along to In a way, they're both yes, but one is closer to the absolute correct answer there. All right, but it's all for a fun quiz here, so there's going to be a little bit of try to make it a little bit vague in some ways just to kind of get you thinking. So a party submits an affidavit signed under I confirm with a notary, but it's without the under penalty of perjury language. Is this acceptable? A is yes, notarization makes it official. B, yes, confirmation is sufficient. C, no, it needs specific statutory language. Or D, no, it must contain under penalty of perjury or similar language. So, question 3, a party submits an affidavit signed under I confirm with a notary, but without under penalty of perjury language. So, which is the right answer? A, B, C, or D for question 3? Again, we have 2 for A and B, for yes, A and B, and 2 for no, C and D, but only one is correct. Fully correct. All right, let's move on as you guys think about question 3, and we'll get to our last.
4426 says 3D.
All right, we got to vote for 3D on that one. All right, that takes us to question 4. While the rest of you tally up your answers for question 3, I'm going to read this one out. A corporate executive submits an affidavit about events they didn't personally witness, stating, I believe this happened based on what I was told. Is this admissible? Answer A is yes.
Facetious Use Expert 587 says 3D.
All right, 3D. Noted. And we're on question 4. The answers here about the corporate executive submitting an affidavit about events they didn't personally witness, stating, I believe this happened based on what I was told. Is this admissible? So, answer A, yes, executives can testify about corporate matters. B, yes, information and belief is sufficient. C, no, it lacks personal knowledge. Or D, no, only witnesses to events can submit affidavits.
Facetious Use Expert 587 says 4D.
All right, you're saying 4D. This is a bit of a tricky question here. This one's definitely the curveball question. So let's look at this again. The corporate, because we read some cases about some different corporate executives also in the previous stream, I believe. And he submits an affidavit about events that he didn't personally witness, stating, I believe this happened based on what I was told. Is this admissible? So it's a little different than the case we read. I'll just throw that hint out there. That said, any other takers on question 4 before we move on to the answers? So the answers again for question 4. Yes, executives can testify about corporate matters. B, yes, information and belief is sufficient. C, no, it lacks personal knowledge. And D,
Bill Famous 4426 says state of mind exception, so okay.
State of mind, all right. We'll give you the exception. D was no, only witnesses to events can submit affidavits. All right, so let's find out what these answers are. And here we go. Question 1 was B. Is it true that you always need sworn affidavits to support a motion for summary judgment? And B, no, you can rely on other evidence, like depositions. And there is no express or implied requirement in Rule 56 that the party moving for summary judgment support its motion with affidavits. The motions can be supported by pleadings, depositions, and other discovery materials. All right, I think we all got that question 1 correct. And now we're on to question 2. Correct answer was B. So an affidavit describes a person's visible physical limitations, but the author isn't a doctor. Is this evidence admissible? And yes, as long as it's based on personal observation, visible, right? And not technical analysis. It's not like a broken arm, right? Describing what you can see with your own eyes doesn't require a medical degree. Lay witnesses can testify about visible physical limitations, while only experts can offer medical diagnoses or technical analysis. So that's that distinction there. Now we're on to question 3. A party submits an affidavit signed under I confirm with a notary, but without under penalty of perjury language. Is this acceptable? And the answer is D, no. it must contain that under penalty of perjury or similar language, under penalty of law or whatever it may be. It has to be some type of penalty, some type of punishment you're willing to take if you lie. The explanation, the network computing case shows that even with notarization, affidavits need specific under penalty of perjury language or similar statutory language. And finally, question 4. A corporate executive submits an affidavit about events they didn't personally witness, stating, here's a key, I believe...
Facetious Expert 587 says, how does one stop overthinking themselves out of the knowledge they know cause? Boy, do I do that here after question 1.
Well, that's the whole fun of doing these kinds of things, is that really there's no consequence for that, but you get to more explore how these decisions come about when you're put the heats on. And that's the reason of doing these kind of fun quizzes here, is it's really low stakes here for honing skills that are necessary, sharpening the saw, so to speak. So we get down to question 4 here, which is another curveball, but the corporate executive says, I believe this happened based on what I was told. So that's clearly hearsay. Is this admissible? No, it lacks personal knowledge. It wasn't stating the company's position on something or other. It's saying, I believe this is based on what I was told. So affidavits shall be made on personal knowledge, in that affidavits based upon information and belief are insufficient as matter of law. So there it is. Summary judgment, part 3, condensed from American jurisprudence. We went over a lot of cases here, quite a few. I think we had over 70 cases that we might have hit tonight. So salute to you all for being here through all of that. I hope you all learned a lot about not just interpreting how these rulings come about, but where the rubber meets the road with the stuff we're learning here from the American jurisprudence. So with that said, we have another one coming up soon, and I hope to see you all on the next one. And thank you all for participating. Thanks all for the super chats.
4426 says fun quiz, but still may cause test anxiety.
Indeed. Well, that's part of the fun of it, though, isn't it? There's no fun without a little bit of stress or tension, so to speak. We want to have a little bit of back and forth to keep us strong. That said, the good thing to keep strong here is our American style of common law and jurisprudence, which I still believe is flawed as many of the hurdles we see along the way. It's still the best in the world. And I think that as we find here and go deeper into these principles here, we'll find out that there is a lot of value in that and keeping that alive for the posterity as it has been here for us. With that said, I thank you all, and I hope to see you all in the next one. Peace out.
Bill Thimmett 4426 says take care all.